There's been a number of last-minute efforts to join a lawsuit currently in front of the state Supreme Court about reproductive rights.
Wisconsin's Attorney General and Governor made a formal effort this week to join it as petitioners. The Catholic Archdiocese of Milwaukee and the Archbishop also want to be named in the same case as respondents. Brittany Schmidt joins us in the newsroom to help us understand these moves. Brittany?
Jeff and Cami, this is more of a procedural step in the justice system, and it's not unusual for parties to try to join cases where there's a significant constitutional issue at stake, and that's what we have here. The case we are talking about is a lawsuit filed by Planned Parenthood against Sheboygan County District Attorney Joel Urmanski. That county has a Planned Parenthood clinic that offers abortion care. The argument in this lawsuit focuses on whether the legislature in Wisconsin could prohibit abortion in almost all cases, or whether our constitutional rights protect against that.
Ultimately, as the Attorney General and with some of our fellow plaintiffs in this case, who are appointees of the Evers administration, we can shed a lot of light, I think, on how the 1849 law impacted women in Wisconsin when abortion was unavailable. And how the court can interpret the state constitution in a way that is consistent with its history, the way it has been interpreted, and its goal of protecting the rights of Wisconsinites.
DA Urmanski was not available for an interview today due to a busy schedule in court, but he referred us to previous statements he's provided to the media on behalf of this case defending the ban on abortions. Urmanski's attorney told the Associated Press the court's ruling will have a statewide impact and guide policymakers. There are a number of factors the court considers when deciding when to let a party join an active case. There are several parties to consider and whether they will be allowed in. There's no date for a decision just yet. Jeff?
Brittany.